The next case to come before the court this morning is State versus Woody. The court is ready to proceed when counsel is, and you will have 15 minutes. It's okay, sorry. You have 15 minutes to present your argument, and you may reserve up to 5. Just let me know.
Thank you, Your Honor. Good morning.
Good morning.
Attorney R.J. Budway, standing in for Attorney Jack Bradley, who represents the appellant, Mr. Woody. The principal argument...
Would you like to reserve some time?
I'd like to reserve 3 minutes, Your Honor.
That's fine.
Thank you. The principal argument in our first assignment of error is the reasonable suspicion for making the stop. In this particular case, there was a third-party phone call by a tow truck driver from Vaughn's Towing, which is an Amherst towing company. That's in the facts. And the indication was that there was a driver driving erratically, and the tow truck driver, Mr. Vaughn, believed he was intoxicated, though we have no idea why that was formulated. Mr. Vaughn did not testify in any proceeding. But that was the allegation. Sergeant Murphy was at Amherst Police Department, jumped in his car, drove an exit over to the Route 58 exit. He went eastbound on Route 2, got off at the exit, and in the video you see him parked at the light. As he's parked at the light, waiting for it to go green, the flatbed from Vaughn's goes by, the white car goes by. He executes a left turn on State Route 58, and he stops the appellant. In watching the video, there appears in the video to be, within the lane, an instance of the car moving left, moving right, and adjusting. All of this happens within 20 seconds. I don't think the officer was behind Mr. Woody more than a quarter of a mile. He put on his emergency lights, he stopped Mr. Woody. Now, at the motion to suppress hearing, and it's on page 12 of the transcript, dispatch advised there was a caller on the line that was reporting possible intoxicated driver that they were following. And they identified
that the identified informant, the citizen informant that gave his name,
yes.
Didn't he actually say that the driver was all over the road?
Well, I'm quoting from the transcript. That might have been in a later part of the transcript that he was all over the road. He indicated that he was all over the road and intoxicated.
Okay, but I just want to make sure, because your first statement was he just said he was intoxicated, he appeared impaired, or he appeared intoxicated.
Well, actually, I think I did say he was all over the road and intoxicated, okay. But I could be wrong, Your Honor.
I apologize.
That's okay, Your Honor. I could be right, I could be wrong. I know, Your Honor, I know that Mr. Vaughn allegedly told dispatch that there was a driver all over the road, he was following, and he appeared intoxicated. Like I said, we don't have any other information.
Okay.
In any event, on cross-examination, well, the officer had indicated on direct that he was behind Mr. Vaughn's vehicle when he took the turn. Then Mr. Vaughn moved out of his way. He was able to pass Mr. Vaughn. He was able to get behind Mr. Woody's vehicle, observe these infractions within the lane in a zigzag, and he stopped them. When in fact in cross-examination it revealed that Mr. Vaughn was actually never behind Mr. Woody, he was in front of Mr. Woody. So the officer was wrong in what he testified to at the suppression hearing. And upon cross-examination it was learned that in fact, after watching the video of the suppression hearing, he did get behind Mr. Woody. There was not numerous lane violations like indicated on direct. There's in fact appeared to be, as I said, a quick left and a quick right within the middle lane. And as you indicated, Your Honor, on page 14, dispatch advised that Mr. Vaughn stated the vehicle was all over the road and that he felt it was an intoxicated driver. When the officer got behind Mr. Woody, he was not all over the road. And there was no other indications of bad driving other than this quick adjustment within the lane. Immediately upon putting the emergency lights on, they stopped Mr. Woody. The officer had indicated on page 18 that he always watched the video before he prepared his report. But again, it appeared from cross-examination he didn't do that. His testimony on direct contradicted what he testified on cross after he watched the video. The only indicators when it comes to probable cause, there was a stipulation that the field sobriety test wouldn't get in, field exercises, with the court for both trial and probable cause purposes, which left two indicators, dry mouth and an odor of alcohol. We don't feel that was sufficient probable cause on two indicators to have arrested him for OVI and then subsequently have him take a breath test. The officer had indicated that Mr. Woody had done this sharp left, then sharp right. Then in a brief moment, he had returned to the right lane. And again, on cross, the officer admitted that this vehicle didn't do sharp left and right. Now, Mr. Woody was charged with zigzagging under the Amherst codified ordinances. Yet there doesn't appear to be a zigzag in the video, nor did he use the zigzag term in his report. And again, there was a number of striking inconsistencies between the officer's testimony on direct versus his testimony on cross. We don't believe, based on this very minutia of this little bit of a left-right within a lane, is enough reasonable suspicion to stop a driver and then proceed with going through the steps that were taken and then arresting him for OVI. I would like to reserve the rest of my time.
Thank you.
Thank you, Your Honor.
Good morning. My name is Frank Carlson. I was the prosecutor for the City of Amherst that handled this hearing in this case. I'm no longer the prosecutor, but I'm still the Assistant Law Director for the City of Amherst. As I understand appellant's brief, the issues that he is raising relate to, first of all, the initials, the justification for the stop. I believe both his assignments of error relate specifically to the stop and not the probable cause for the arrest. He's also raised the issue of whether or not there is an abuse of discretion in connection with the sentencing in this case. From the state's point of view, obviously we believe that there was a sufficient basis for the stop in this case. That what we had was a call in by an identified citizen informant. Lieutenant Murphy testified later that he knew who David Vaughn was, that he was the operator of the local tow company. The description that we've already talked about is that the defendant's vehicle was all over the road and that the caller had a concern that he was a possible impaired driver. So this information is relayed to the officer through dispatch. He's given information about where the defendant's vehicle is. In fact, Officer Murphy was exiting State Route 2 at Route 58, intending to intersect that car. The vehicle was in a position where he had expected it to be based upon the information coming through dispatch. In fact, he identified Mr. Vaughn's vehicle and identified the vehicle that Mr. Vaughn was referring to in the information. He followed the vehicle for a period of about just a quarter of a mile and observed weaving within the lane. The state believes that the stop could have been justified even without independent observations by the officer. I know the court is aware of the Supreme Court's ruling in Navarrete versus California. And that had, I would say, similar facts to those involved in this case, that there was a citizen informant who was identified who gave information to the law enforcement that was conveyed to the trooper in the field, and on the basis of that information and certain kind of internal indicia of reliability. In other words, you know, the vehicle was described, the officer saw the vehicle where he might expect it to be, the stop was initiated, and Justice Thomas said that the tip itself was a sufficient justification for the stop under the Fourth Amendment. So we believe that the circumstances in this case, there were sufficient indicia of reliability in respect to the tip that the stop is justified. But we have somewhat more than that in addition, because we have the description by the officer of the vehicle moving within its lane. Whether that would have been independently a sufficient basis for the traffic stop, I don't know. But the state's position certainly is that that was information that corroborated the information that had already been communicated to the officer. Amherst does have an ordinance that prohibits weaving within its lane, although the Ohio Revised Code does not. But in any event, that the observation of the movement of the vehicle is certainly one that would give rise to a suspicion that the information that had already been obtained through the informant was reliable. We ultimately had the stop, the accumulation of evidence necessary to arrest, and then the defendant tested in this case, and he tested at a .237. I think that circumstance itself lends credibility to the judge's finding, at least, that the officer did observe weaving within his lane. And the trial court, in its opinion, said that that was one of two bases for the stop.
Well, counsel, we can't look at the fact that he flew over the legal limit to justify or even lend credibility to the officer's observation.
Well, I was thinking about just that question, Your Honor. From the trial court's point of view, when a case like this comes to you, there are mixed questions of fact and law, and this court is bound to accept the conclusions of fact of the judge where they are based upon some competent and credible testimony or evidence. In this case, I would say that the trial court may have relied upon that finding of its knowledge of the test result in determining that the officer's testimony was credible in respect to the observation. That's just a thought that I have, and the court, of course, may choose to disregard.
Well, that's a little concerning, and it's just like saying, you know, that you pulled somebody over and the officer testifies that they consented to search their car, and he said, no, I didn't, and they find drugs there. And so they're like, well, we found drugs, so, but this, I mean, I'm not sure I understand why that would have anything to do with whether or not the officer's telling the truth.
Well, I guess
whether
my argument,
that was the credibility of the officer, I guess is what I'm trying to figure out.
I guess what I'm saying is that if this individual has a blood alcohol level of over
Then he
3
can't drive
times,
well.
then the court, an inference might be raised that yes, he's not going to be able to drive well, and yes, Officer Murphy's testimony that he was weaving is therefore credible. That I don't know if it's
I
a
just
large.
feel like maybe the tail wagging the dog or something,
Well,
you know, I'm just concerned over that. I don't know, I'll think about that. But
I understand your argument, Your Honor. It's one thing that I was thinking the same thing as I was driving. So, the other issue that counsel didn't discuss but may discuss in its final closing is the issue of the appropriateness of the sentence, whether there was an abuse of discretion. And as the judges understand, that's the standard of review is whether there was an abuse of discretion. And in this case, we had a young man who's had 3 alcohol-related encounters with the court, He had an underage OVI some years prior. He had an OVI within 6 years, so this was a second offense within 6 years. So the court is naturally concerned about this individual and wants there to be a sentence imposed that is going to be meaningful to the defendant and is going to be one which is going to hopefully change his decision-making process and his life as well. So the fact that he imposed a 30-day jail sentence I don't think is extraordinary. I think it reflects the fact that the court takes these kinds of cases seriously from the point of view of safety to the public, from the point of view of safety to the defendant, and from the point of view that alcohol with an individual is an intractable problem that can ruin his life. And
what were the 3 offenses again?
there was operating a vehicle after underage consumption, so we call those underage OVIs. And then there was actually a prior OVI within 6 years, and then this one with a high alcohol level as well. So the court wants to know that it's going to do something that is going to set this young man's life on the right track. And I don't think there's an abuse of discretion. I don't think a defendant has a right to a minimum
Does
sentence.
the 30 days encompass a program?
Our judge doesn't, is he required as a condition of his, well, in this case, the defendant was placed on intensive probation supervision, and that requires that the defendant have an assessment, be subject to random testing, follow any recommendations of the assessment. Sometimes the assessment itself can tell the court the defendant needs to be placed in a rehab center. And the court would, of course, follow that as a condition, as the case would unfold in its community control department. But there was nothing in the sentence itself that required that. So that's, if there aren't any questions, that's what the state has to say.
Thank you.
Thank you very much.
You still have 5 minutes.
Again, Your Honors, we're, for the purposes of today, focusing on reasonable suspicion. The trial court had wrote in its entry opinion on the motion to suppress that while following the vehicle, Sergeant Murphy observed the vehicle weaving in its lane, touching the white lines on each side of the road in a zigzag motion. At one point, may have crossed the dividing line between lanes, and at one occasion jerked to maintain its lane. On cross-examination, that wasn't the case. So I don't know if the trial court just selected just to ignore the cross-examination and ignore the testimony of what was brought out in cross-examination. The trial court had indicated in its decision that it did review the video, and the observations that the court stated that Sergeant Murphy testified to and put in its findings of fact as part of this decision isn't consistent with the video reveals, which is within one occasion the vehicle moves left, moves right, adjusts straight. Now, as the prosecutor said, and I think we're all guessing the amount of distance, it's estimated that he followed Mr. Woody for about a quarter of a mile. We didn't get there wasn't a precise measurement entered into evidence that may or may not be accurate, but in watching the video, there couldn't have been more than 10, 15 seconds of the officer following Mr. Woody. And in that brief period, he observes this brief left and right within the lane. With regards to the informant, as indicated, the informant indicated that he was all over the road, he appeared intoxicated. Also, the belief was that Vaughn was right behind Mr. Woody, when in fact from the video, from the testimony, that wasn't the case. I know that the court is going to look at the weight and reliability of a third-party report. It doesn't appear that the trial court considered that in this case. Also, again, Mr. Vaughn did not testify at the suppression hearing. Again, with that, we don't believe that there was enough evidence of erratic driving, of a traffic violation, of a violation of the Amherst Code that justified this stop. And we believe that the decision of the trial court should be overturned based on that.
Thank you.
Thank you, Your Honor.
The court will take the matter under advisement and issue a written opinion that will be sent to both sides. And we also release our cases electronically, so you can look on our website. Thank you. We're a few minutes early again. The next case is Wallace v. Wallace.
It's at 11:30.
Oh, we're really early then. Okay, we'll be in recess.